Here we go. Good morning, everybody. My name is Rita, and I am the Program and Technology Specialist for the Wood County Committee on Aging. I welcome you today to our Monday morning presentation with Judge Matthew Reger, and he is from the Wood County Common Pleas Court. Now, if you missed last week's session, he reviewed kind of like a Constitution 101. It was a basic introduction. And we do have that on our WCCOA YouTube channel. You're more than welcome to catch up. But today is part 2, and he's going to be reviewing the Judicial Review and the Civil War Amendments. So please welcome Judge Matt Reger to the floor.
Okay, thank you very much, Rita. I guess I want to start out is I'll give a recap of last week. When we were last week, the very end of our meeting was about the Constitution. That's when we got to the Constitution. So, as a recap, it's 1787 right now, and that's where we're at. What had happened previously is in the 1750s, the French and Indian War had occurred. During the war, the British, in the desire to win the war, had spent outrageously on it, and then afterwards needed to fund that expense, and so that came down as taxes on the colonists. Britain thought that because they had secured this for the colonists, that they needed to basically tax these people to pay for this endeavor. So that's one aspect of it, and we talked about that. That's the tax aspect of it, and that was a motivation for the people in the cities to be able to revolt. So that led to things like the Boston Tea Party and things like that. And those are the things we recognize. We talk about taxation without representation, we talk about the Townsend Acts, we talk about the Intolerable Acts. But another aspect that we don't talk about is out of the French and Indian War came a compromise or a treaty that Britain had entered into, and this was a treaty with the Indians, or the Native Americans who had fought alongside of the British, was not to settle anywhere west of the Appalachian Mountains. And to a lot of people who were land speculators, in particular a wealthy class of people, or people who knew about the Ohio Valley, that was not acceptable. They wanted to be able to settle and to speculate on land that was west of the Appalachian Mountains. So those are two primary things pushing the revolt, the revolution, as we call it. And the revolution coalesces, as you know, there is Lexington and Concord. That's in 1775, but it really coalesces around an idea with the Declaration of Independence. And so we have that idea, and we talked about that. That creates the beginning of the idea that America is. And that's what says that it starts out with the idea that we hold these truths to be self-evident, that all men are created equal, endowed by their creator with certain unalienable rights. Among those is life, liberty, and the pursuit of happiness. And we talked about that a little, or I talked about it a little, is that when it says unalienable rights, that means within the Thomas Locke theory of government, that these are rights that are retained. These are rights that were retained by by individuals who enter into a government. And so life, liberty, and pursuit of happiness is what the Declaration of Independence says. So those are retained rights is what it says. Now, when we get to the Constitution, we talked about this, we have kind of a conflict with that, because the Constitution in the Fifth Amendment says that life, liberty, and property can be taken away only by due process. So when we get to that idea, I want you to think about how that creates kind of a conflict, is that if life, liberty, and the pursuit of happiness are inalienable rights, or rights that can't be taken away or held by the person, how can due process take those away? And so those are the conflict that continues today with the Constitution. Question I had, George Washington, I believe, was interested in or even bought land west of the Appalachian Mountains when we were still colonies. Yes, actually Washington during the French and Indian War had surveyed, or even before the French and Indian War, had surveyed areas that today would be called the Ohio Valley, even up into Fort Pitt, which would be Pittsburgh, and even a little west of that. And yes, George Washington wanted to speculate on land that was west of the Appalachians. And so that was a primary motivator for him in regard to that. I do believe also, I hate to, in today, many times when we talk about this, I hate to say that there's one thing that was a motivator, okay? As I talked about when we discussed this before, I talk about the professor who, the student raises his hand and says, what was the one thing that caused the American Revolution? And I said this last time, and the professor's response is, well, I guess it's just one damn thing after another. And the fact of the matter is that I can't say that George Washington was motivated by his interest in the Revolution primarily because he wanted to speculate on land. Was it a factor? I'm certain it was. But I think also that Washington believed in the words of the Declaration of Independence, and it gave he and his colonial army, the colonial army, the motivation to continue on with the fight. Remember that, kind of think about the context of when the Declaration of Independence came out. The Declaration of Independence is signed in July of 1776. It is read to the troops who were most stationed with Washington on Manhattan Island in New York on July 9th of 1776. Prior to the signed Declaration of Independence, people didn't know what the reason was for the revolution. What are we doing this for? What are we fighting it for? Is it just to get rid of England? Some people would tell you, well, we like England. We like the things that are there. In fact, it's well known that, or it's well documented that many of the British troops, when they came here, could not understand why the colonists wanted to engage in a revolt when they had everything they could want. Many of the English said, we don't have the things you have. We don't have the resources you have. Why in the world would you want to revolt against a government that is so benevolent? And that was kind of the thought. So the revolution ends in the 1881. Treaty of Paris is signed in 1882. And so we've had 6 years of war, and now government needs to be formed. And understand that one of the primary driving forces is a fear of a centralized government. Britain is a centralized government. And so in 1782, when we form a government, we come up with a government that is under the Articles of Confederation. This is a very strong state government program. The federal government only got money when the states said they got money. They had very little ability to pay the things that we would expect out of a centralized government. For example, very important to George Washington was the fact that his troops weren't being paid. Many troops were on the verge of a revolt because they weren't being paid. And so these things were motivators, I guess, and you think about it. One of the ones that we are familiar with is Shay's Rebellion in Western Massachusetts. These are people who had fought in the Revolutionary War and were not getting paid. And so they wanted their pay. The federal government, or what would be the government at that time, the central government, didn't have the ability to because the states weren't providing them money. And so there was a real motivating factor to create a centralized government. And so that begins the division between two forces in America: the Federalists, who believe in a strong central government, and the Anti-Federalists, who believed in a smaller, less centralized government. I think you can see that that is still a debate today. I mean, I don't think there's a question that we are still debating today as to what the role of the federal government is. I will actually send it out later. I'll send this on to Rita or to Liz, but I have a chart here on federalism, and think about these things. Okay, in 1787, education, would that have been a federal government role, or would that be a state government? pretty much I'd say it would be a state government role. Foreign affairs, national. Immigration, national. Voting was and still is a state government issue. Most voting rules are defined by states. So you have these competing interests that want to have either a strong federal government or a less stronger or smaller federal government. As you know, the Federalist Papers, James Madison, Hamilton, and John Jay write these. And Hamilton writes primarily most of those. And Hamilton is a primary proponent of a Federalist idea. He believes in a strong federal government for a lot of reasons, partly because of trade, because of financial interests. Understand that most of the people in the cities support a strong federal government. Hamilton was one of those. He was also influenced by Washington's desire for a strong federal government. And so you have the two different groups. You have the Federalists and the Anti-Federalists. Federalists they do a great job of articulating their points through the Federalist Papers. And that's primarily through the work of Hamilton. Alexander Hamilton was a proficient writer and a prolific writer too. And so he came up with these proposals. So in the summer of 1787 begins the process of creating a constitution. And it does not look promising at first. There does not seem to be much agreement. The delegates are sent, but they only have one vote per state. So I want you to think about this constitutional convention. And there were three delegates. I'll give you the best example of that is that there were three delegates sent from New York. Alexander Hamilton was one of them, but the other two were opposed to the Constitution. And Hamilton therefore had no ability to outvote them. So what he did was he focused all of his attention on writing the Federalist Papers and advocating for federalism. Now, part of the reason that there was not support in New York was the governor at that time was George Clinton. And Governor Clinton did not believe in a strong central government. He wanted to consolidate his own power. Understand there are competing interests here of what people want. So at the beginning, you have these arguments between the Federalists and Anti-Federalists, small states, large states, city versus rural interests. Some of the things I think you still see today. Now, the big argument is over how does this government look? What does it, how is it composed of? How does it, and in particular, that focus was on the legislature. They came up with a plan for the three branches of government, but they focused on the legislature. And the big part was, how do we represent people? This is a representative government. How do we do it? So we have the Virginia plan, which is two houses, each proportionally represented. So you have a large Congress, but then you have a Senate, which is composed also proportionally. Obviously, a state like Virginia, which had a large population at that time, was a wealthier state than other states, would not have wanted to, would want a proportional. But you think about other states like New Jersey, at that time also Delaware, Rhode Island, much smaller states, they would not have wanted so much of a proportional representation. So we also understand that part of this was also motivated by debt. Southern states, particularly Virginia, had no debt. In particular, did not have debt related to the Revolutionary War. Most of the war was fought in the northern colonies as opposed to the southern colonies. And so those southern states did not have a great amount of debt. The northern states, particularly Massachusetts, had a great amount of debt. Southern states did not want to have to take that debt on. And so that was a big issue. And so the other plan for representation in government was what's called the Small State Plan or the New Jersey Plan. And it called for one house, but one particular house, but there's only one vote per state. So you'd have one house with only 13 members. That wasn't acceptable to the larger states. So then you have what's called the Great Compromise. Two houses. The House is based upon states' population. The House members are based on states' population, and the Senate has an equal number, two per state. Well, even that has its controversies. The House, in determining a state's population, southern states, which are primarily populated or largely populated by slaves, want a greater number because they have a greater number of people in the representation, and therefore leads to what we call it part of the Great Compromise or the 3/5 Compromise, which is still today is an embarrassment to our country, because what we did at that point is enshrine slavery in the Constitution with the statement that all free men were entitled to a full representation, whereas those who were slaves were entitled to only 3/5. And really understand that their representation was by their owners. So their owners are going to have a larger, people who were slaveholders were going to have a larger role or larger voice. And that was an aspect of compromise in the Constitution, which there could have been a better way, but I don't know that they could have seen the better way. I always like the analogy made by Jefferson to this. Jefferson said that slavery was like holding a wolf by its ears. You didn't like it, but you didn't want to let go. I don't know that, I mean, it's an analogy that he uses. We can put our standards on the people in 1787 and say they could have come up with a way of eliminating slavery and making a constitution. I guess there could have been, but I don't know, in looking back, how that could be. I will say though, and I want you to think about this, is that in 1787, they also passed the Northwest Ordinance, which provided for free education and the elimination of slavery in the territories in the Northwest, which would be Ohio, Michigan, Illinois, Indiana, and Wisconsin. And so if they could have done that in 1787, why couldn't they have done it with the Constitution? I think there's a lot of other interests and a lot of things that were ingrained at that time. And so unfortunately, it took a civil war to resolve that. And we're going to get to that in a few moments. But before we do, I want to tell you, so the Constitution is passed. I've talked about some of the compromises that had to be made, some of the conflicts. I could spend the rest of the hour talking about all the conflicts that went in. But we create a document that creates three branches of government: an executive, a legislative, and a judicial. I think the intent of the founders was that the legislative would be the strongest part of government. They were in control of the purse strings. Now, there was an idea originally of the executive that maybe it be three people, or that it be comprised in a way that did not have someone who looked like a king. In fact, one of the things that, as I understand, is that when they were at the Constitutional Convention, an individual stood up and said, well, what if we just had one president? And everybody kind of stayed quiet. Then Benjamin Franklin stood up and said, well, we at least should discuss that. We should at least discuss that issue. They were afraid of that. They were afraid of one person. They knew what a king was. But I think that what helped that discussion move forward is that they understood, and I believe completely that the founders, when they adopted the Constitution, what they saw as a president was George Washington. I don't think there's any question that they were pretty much unanimous in believing that George Washington was who that chief executive would be and what that chief executive would look like. So they create this, the Constitution goes out, it needs to be approved by 9 of the 13 colonies. It is a controversial document. And I will tell you that half the country was in favor of it and half the country wasn't. Because of the Federalist Papers, because of the articulation by Alexander Hamilton and others, including James Madison, it was passed ultimately, and it did get the required number of votes. Ultimately, New York passed it after it passed the 9 votes. They were opposed to it, but once it had passed, they did agree to pass it. So then you have a constitution, it's created, and also, as you know, at the same time, part of the compromise that the Federalists came, understand that one of the arguments between Federalists and Anti-Federalists was a strong central government was believed by Anti-Federalists to be a way to take away liberties. That a strong federal government would trample on all their liberties. That it would take away the rights that they believed were theirs. And so the Anti-Federalists insisted that in regard to the passing of the Constitution, that there needed to be these 10 Bill of Rights. They were passed alongside the Constitution. There was an agreement, basically, that the Bill of Rights would be passed with an agreement to pass the Constitution or accept the Constitution. And many states were opposed to the Constitution at first, but with the addition of the Bill of Rights were willing to agree to that. So you have a form of government, you've got this created government, there's intents of what it looks like, and then basically they let it go. They said, okay, here it is, start it. So federal government begins. They have a Congress. Their representatives are sent there, both to the Senate and to the House. There's a president, he's elected. And then there's a judiciary created. And understand that the Constitution created only the Supreme Court. It did not define the number of members. It did not define the composition of the federal courts. And so that is the Judiciary Act of 1789 that is passed that creates a judicial system at that time. It creates the system that's not exactly as it is today, but it creates a trial court, an appellate court, and a Supreme Court. One of the things that's included in the Judiciary Act of 1789 is it creates what's called original jurisdiction for the Supreme Court. It creates a list of cases, or a list of types of cases that can have original jurisdiction in the Supreme Court. And that means that the case can be filed in the Supreme Court. And we're going to get into some complexities here a little bit. If at any time I get way off track or I'm talking too technical, please stop me. Please put something into the chat message. Please speak up. Or I may not be talking too technical for you. Maybe you're thinking I'm being too simplistic. And if I am, please tell me. I'm trying to make this so that everybody can participate. And then also, if you have some thoughts on this, at any time, please put those out there. So the government's formed. We have our first president. And then I think the first constitutional challenge comes when when George Washington says that he's leaving. When George Washington serves his second term and says, I'm not going to not going to be president anymore, this is probably the first constitutional crisis. Nobody knows what it looks like to peacefully pass power. Understand what the context of these people are, is that their context is a king who inherits. And prior to that, they knew about the British Civil War or the English Civil War. So they really didn't know what peaceful power transfer was. And also understand in the context of this, and I want you to think about this, is that the French Revolution is going on at the same time the United States Constitution is being formed. And think about how that could influence. Jefferson was in France at the time and highly influenced by French governmental ideas, French ideas of liberty, equality. And so, understand how those kind of work in. So in any event, it's 1796. George Washington has been president for 8 years. His vice president is going to run for president. It's John Adams. He runs, he wins, and there is a peaceful transfer of power. So the next big constitutional challenge would be 1800. There is a direct conflict between Adams and Jefferson. They fight a bitter campaign, and at the end of it, there's a real question of how power will transfer. But Adams transfers power. But understand this, right before that transfer of power, he appoints a large number of judges to the federal bench. And in particular was a guy named John Marbury, who was appointed to a Justice of the Peace bench in Washington, D.C. Now, the way that happened is that just like today, John Adams sent a list of people that he wanted appointed to the bench. Now, it was interesting that he leaves the office on March 4th. This list is sent on March 1st. On March 2nd, it's approved by the Senate. And on March 3rd, those appointments need to be delivered. The person in charge of delivering them is, oh my gosh. My mind is not working as well as I thought it would be. And I'm sorry, is John Marshall. John Marshall is the Secretary of State, and he's in charge of delivering these appointments to these respective courts. Many of them get out, but one of them doesn't get to Mr. Marbury. And Mr. Marbury does not receive his appointment. It's a document that says he's been appointed. Now, the president has done the appointment. It's been approved by the Senate, but the commission has not been delivered to him. Marbury then sues. He sues the next Thomas Jefferson Secretary of State, who is James Madison. And so it's Marbury versus Madison. And he files that in the Supreme Court. And the reason he files it in the Supreme Court is because the Judiciary Act of 1789 says that's who has original jurisdiction. So, I need to get something here. My pocket constitution. I encourage each one of you to get a pocket constitution because I think you're going to need it at some point. I think it's always important to have. So, here's I'm going to lay the groundwork. Marbury is suing, John Marbury is suing James Madison because he did not get his appointment to the Justice of the Peace for Washington, D.C. The suit is filed in the United States Supreme Court. Well, what's interesting is that the Supreme Court doesn't meet for almost 2 years, and that's primary through the acts of Thomas Jefferson. And why it didn't meet is one of the people who gets appointed right at the end of of Adams's term is John Marshall. John Marshall, who's the Secretary of State, gets appointed to be Chief Justice of the Supreme Court. And so it doesn't meet for 2 years. Well, in 1803, the case ends up going to the Supreme Court. And the Supreme Court ultimately issues a decision written by John Marshall. And this is really kind of interesting. Understand, this case, one of the central figures in it is John Marshall, and he's the justice who writes the opinion in this case. In this case, Marshall says that first, that John Marbury was entitled to his commission. It also says that he did file the right claim, which was a writ, a particular writ that he had filed, so that was appropriate. Then the next thing was he did not file in the right place. And the reason he didn't file in the right place was because the Judiciary Act of 1789 was in conflict with the United States Constitution. This is the important part of what's called Marbury versus Madison. In this case, so we go to Article 3, Section 1. Okay. Okay. Judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Now, then it goes on to say, Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction. Okay, then it goes on to the things that should be, okay. It says, but here's the key part. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations the Congress shall make. Marshall's decision says that the Judiciary Act of 1789, giving original jurisdiction to certain cases other than what is defined in the United States Constitution, made that act unconstitutional and therefore was not a valid law. This is the very first time that the Supreme Court has exercised what is called judicial review and has said that the Constitution is the supreme law of the land, and therefore laws made by Congress can be found to be unconstitutional. This is a radical idea. I want you to think about this. What Marshall is saying, that a law, even a law passed unanimously by Congress, can be found to be unconstitutional. Understand, we accept that today. We even we accept it as something that is part of our complete system. We accept that and we take that. But understand, at that time, that was just outrageous. To think that something could be passed by a majority or an overwhelming majority or even unanimously could be found to be unconstitutional by a single court just was beyond the concept at that time. But by doing that, Marshall firmly established the judiciary as a strong branch of the three branches of government. So I want you to think about that, is that first we have a legislative branch. Their power is in the purse. They have the ability to give money or not give money. The executive, he has the military. That's his power. And the judiciary, prior to this, had no power, really had no power, or almost ministerial acts. But, and that may have been the image of what the founders wanted. But what happens with Marshall's pen in Marbury versus Madison, he creates the power for the Supreme Court. And that power is respected still today. And that's an interesting part. I kind of want to do a little bit of what I call a rabbit trail here. I want you to think about that. I think everybody in this group right here remembers a particular case. And that particular case is United States versus Nixon. And I like to use this as an example. In United States versus Nixon, the United States government, represented by the then Attorney General, and remember the midnight firings, but the Attorney General, well, through the special counsel, is suing the president, asking for the release of certain tapes that were made in the Oval Office. The case ends up going to the Supreme Court, and the Supreme Court issues an order saying that the president must release those tapes. So now, what does the Supreme Court have to enforce their order? I always put it in this context, is that they have a bailiff. He has a gun, and so he's got this order from the Supreme Court. He walks down to the White House, he knocks on the door, he says, Mr. President, I have an order to give me the tapes that you have. Now, the president has two options. He can give the tapes and say, okay, you've got this order, or he can say, I don't have to listen to you. Well, Mr. President, I do have a sidearm. And the president can then say, yeah, but I've got the 82nd Airborne. I've got the 101st Airborne. I've got the Secret Service. They all work for me. I'm not listening to you. Whatever you think of Richard Nixon, the fact of the matter is that at that time, he respected the rule of law and abided by it and gave over those tapes because there's this established precedent that the Supreme Court's rulings have force of law. And so that law was respected. So we go back, it's 1803, Marbury versus Madison has established that there's the idea of judicial review. Now, we move along and we have this, and then comes the Civil War. The Civil War is probably the single most important event in American history. It redefined the country. I told you at the very beginning last week, we talked about how do you refer to the United States? Is or are? Well, prior to the Civil War, most likely you would have referred to the United States as an are. The United States are. After the Civil War, it becomes the United States is. Now, we know some of the Civil War amendments. The 13th Amendment, which banned slavery. But the 14th Amendment is the single most important event in constitutional history. It includes what's called a due process clause. I know that you probably have heard of the due process clause. The Fifth Amendment has a due process clause, and I've read that to you, and I'm going to read it to you again. I'm just going to read it right from there, from the Fifth Amendment. It says, okay, no person shall be deprived of life, liberty, or property without due process of law. Now I'm going to read what the 14th Amendment says. Okay, no state shall deprive any person of life, liberty, or property without due process of law. So what it did was it took and applied the due process clause to the states. So let me put this out here to you. Prior to the passage of the 14th Amendment, the first 8 amendments of the United States Constitution applied only to acts done by the federal government. Put it in this context. Let's take the First Amendment. The First Amendment has 6 different protections in it. One of those protections is freedom of speech. If the state of Massachusetts in 1801 had passed a law that said no one may speak disparagingly about the governor of Massachusetts, nor make any sign against the governor of Massachusetts, you would recognize that as a violation of the First Amendment. But it's an act of a state against a citizen of a state, and therefore, in 1801, would not have violated the First Amendment. The 14th Amendment, though, includes this due process clause that says that no person may take away life, liberty, or property without due process of law. No state may take away life, liberty, and property without due process of law. Now, therein lies another thought that we have to talk about, is that passage of the 14th Amendment did not automatically make those other amendments applicable against the states. It took cases over time, and there was a divergent opinions. Some thought that there was full incorporation of the first 8 amendments against the acts of the state. Some thought, no, it's a selective incorporation, certain parts and certain amendments. And what we've taken is that over time that it has been a select incorporation. Over time, all of the protections in the First Amendment have been held to be applicable against the states. The Second Amendment was not applicable until again to the states until about 10 years ago. The Third Amendment has never been made applicable against the states, but as you know, the Third Amendment has to do with the quartering of soldiers. The Fourth Amendment was made applicable against the state, as was the Fifth, the Sixth, and portions of the 7th, one of the things that's never been incorporated is the constitutional right to have a criminal charge presented by a grand jury. In the state of Ohio, that protection for a grand jury is under the Ohio Constitution and not the United States Constitution. So we've gone over a lot of things here, and these are complex issues that are still part of the legal framework today, and in fact influence our constitutional and legal discussions today. We put in that point. By incorporating those protections, we have led to a long line of constitutional challenges that invest a great deal of power in the Supreme Court. So let me walk down that path with you. First of all, Marbury versus Madison in 1803 says that there's judicial review. Then, with the Civil War Amendment, particularly the 14th Amendment, it says that the first 8 amendments, in part, are applicable against the states or acts of the state. And so that results in the proliferation of different kinds of lawsuits. Remember, most of those are in the 20th century. Most of the First Amendment litigation all take place during and after the First World War. Much of the litigation involving the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment all happened in the 20th century. And much of it happens after World War II. And so what that does is it puts a lot of power in the Supreme Court. And so the Supreme Court then becomes a strong political entity, and therefore it becomes important on who is on the Supreme Court. As we know today, we are starting a Senate Judiciary Committee is having hearings involving the appointment of a new Justice of the Supreme Court. We all know that Justices of the Supreme Court are now a political football within presidential politics. And so who gets appointed is really important. It's because of this line of cases and this proliferation. But there is, and I want to bring this up, some people out there who've advocated that maybe there's a better way. Maybe rights should be defined under state constitutions. And maybe, and what's happened, most state Supreme Courts have said that whatever the United States Supreme Court says is what we will say is applicable to our issues involving Fourth Amendment, First Amendment, Fifth Amendment, Sixth Amendment issues. Now, there is a possibility, though, of creating a system of advocacy under state constitutions, which could expand rights within the context of a certain state. You can think of a situation where maybe there is a need for greater protection in certain states, but less protection in another state. I'll give you the example under the Second Amendment. I think that maybe you could see a situation where maybe there is a greater need for certain rights to the possession of firearms in Montana, as opposed to in New York or in Chicago or other places. It's something to at least discuss. Now, I've talked about a lot of complex issues, and I've kind of gone over them with a broad brush. And I know that sometimes this is really, there are encompassed in this, as I said to when I began this is a legal discussion. It touches on political issues, and I'm trying not to make this political. What I'm trying to do is say these are legal issues that we've talked about. We've talked about some big, broad legal issues. And so I'd really like to open it up. I'm hoping that maybe there's some discussion points. We've got about 12 minutes left. I'd really like to see what kind of discussion is out there. So Rita, you have anything or?
Yeah, I will prompt everybody to unmute themselves, and you are more than welcome to join in the conversation and contribute something for Judge Reger or ask a question.
I have a question.
Go ahead, Julie.
Yes, I was wondering I had a daughter that served on a grand jury. She lives down near Cincinnati, and she went like a whole month. And she went every day, and they give her all these cases. And then they decide which ones are worthy of prosecuting and which are not. How do they do it for the Supreme Court?
Well, so the Supreme Court, that's a great question. Okay, that's a great question. The Supreme Court deciding what cases come before the Supreme Court, first of all cases come to the Supreme Court by appellate jurisdiction, except for the ones that I told you have original jurisdiction. The Supreme Court, to get a case to the Supreme Court, you have to go through certain appellate procedures. In the federal system, you'd have to start out with a district court and then appeal it to an appellate court, or what's called a circuit court, and then you can appeal it to the Supreme Court. In a state court system, so we'll just use Ohio, you would start out your case in a trial court, which would be either in a municipal court or in a common pleas court, appeal it to an appellate court, appeal it to the Ohio Supreme Court, and then you could appeal it to the United States Supreme Court. When you appeal a case to the Supreme Court, or when a person does, they file what's called a writ of certiorari. A writ of certiorari is a request for the Supreme Court to hear the case. The United States Supreme Court has about 8,000 requests each year for cases to be heard. Typically, the United States Supreme Court hears somewhere between 50 and 80 cases a year. The determination of what case is heard by the Supreme Court is determined primarily based on the legal precedent that it would have. It has to be a case that presents either a novel or important legal issue. In regard to this grand jury, the Ohio Constitution guarantees that anyone charged with a felony will have that charge reviewed by a grand jury. The idea behind a grand jury is to have citizens review cases brought by a prosecutor. In most cases, the grand jury votes to indict somebody, but in some cases they question the prosecutor and they don't agree with what the prosecutor wants to do. This was meant as a protection against too much power in the hands of the prosecutor. You know, in Wood County, just so you know, a grand jury, a member of the grand jury usually serves for a 4-month period and meets twice a month, usually for a whole day. And they do hear a number of cases within that full day. I hope that answered that.
All right, that was a great answer.
Other questions, other thoughts out there?
I thought the first part of your talk was very interesting to me. It was a history lesson refresher, you know, and, you know, the fact that Washington and Hamilton and Madison would fall into the Federalist camp. And I was wondering, could you mention some of the prominent figures of that time, of that era, who were anti-Federalists?
Well, probably the most prominent anti-Federalist would have been Patrick Henry. Patrick Henry did not believe in the Constitution at all. And he was afraid, what he espoused was that if we had a Constitution, and he was a prominent slaveholder, he said that that would be a pathway to taking away slaves. Ultimately, that's what happened. But Patrick Henry was, and you know, Patrick Henry was probably the most prominent person against a constitution. There were a lot of others. As I said, Governor Clinton in New York was, because he had a lot of power in being the governor of New York. Many people who were in power did not want this centralized government because they knew that it was going to take away power from states. Thank you for the comment on the first half. I'm sorry if the second half got too complex or maybe I lost anybody. I didn't want to. I know that sometimes when people hear that, they say, well, I didn't know that, or I didn't know that at all. So
it's very interesting. All of it is. Now, a personal question, you clearly know a lot about history, obviously, because of what you do, but when did that start? Did you remember as a kid really loving history and engulfing yourself with it? Or was that more of an, did that come with adulthood, I guess?
So that's a funny thing is that, no, the love of history came, and I can even kind of point out the time. 1975, I was 8 years old, and I had this real interest. We had spent, my grandparents had a farm in Manassas, Virginia. And I grew up every summer going to Manassas and spending my time there. And there was a deep connection to history there. And then Washington, D.C. also intrigued me. And in the Christmas of 1975, my grandmother gave me what was called the Bicentennial Almanac. And it was a listing of dates from the founding of the United States up to 1975 that were important. And I just read through it all the time, and I became just enamored with history. And so today, that's what I read. I mean, most of the books I read are history books or books on history or biography or something. So that's, that's my passion, I guess I would say.
Thanks for answering.
Thanks. I mean, as a lawyer also, I would tell you that our legal system and the development of our law is so connected to the history of our country. They can't be unconnected.
Right. Agreed. All right. I think we probably have time for one more question if anybody has anything.
I understand that RBG carried the pocket edition of the Constitution with her pretty much at all times. Did that include the amendments?
Oh, yes. Oh, yeah. It includes all the amendments. I strongly encourage everyone to get one of these. And when somebody comes to you and says, oh, it's in the Constitution, tell them, ask them, well, where is that in the Constitution?
You can impress them by having that in your back pocket or your purse.
Since RBG probably had it pretty well memorized, do you think she just carried it for the, if the question came up, she could show others?
Well, I think that I can tell you, I would tell you this. I would expect all of our Supreme Court justices to carry a copy of the United States Constitution, and I think they all do.
Mm-hmm.
Understand, I think that RBG or Ruth Bader Ginsburg probably had a good knowledge of the Constitution, just like her fellow colleagues who were on the opposite side had the same knowledge too. So one of the things I'll throw out there to you, okay? We're going to talk about it next time. We're going to talk about a case next time called Griswold versus Connecticut. And it deals with the right of privacy. Now I'm going to challenge you. I want you to go through the United States Constitution for the next week. And I want you to find and be able to point out to me the right of privacy in the United States Constitution. Now, the reason why we're going to talk about Griswold versus Connecticut is because there's another case that is much more controversial that we could talk about the right of privacy, but if we did, we would get off on issues that we don't want to talk about. We're going to talk about what is called the penultimate case to Roe versus Wade, which is Griswold versus Connecticut.
Good. Well, we have homework this week then. We'll have to find our pocket Constitution.
I thought I was beyond that at my age, but I'll go for it.
Yeah.
Well, I encourage you to look at the Constitution. If anything comes out of this, if you're reading the Constitution and when you talk to people and they tell you, oh, it's in the Constitution, be able to do that. I mean, I guess really, does everyone see that the issues that were going on in 1787 are still alive today? The issues of states' rights, states, should states have this power or who has the power to decide a certain matter is still debated today.
Yeah.
Judge Krieger?
Yes.
When my son was doing long haul truck driving, he still always carries the Constitution with him because they get into arguments, and truck drivers are full of BS, and he could always say, now find it for me, and they'd look and they could never find it.
Mm.
And I have like 3 copies I've got a few years ago, and I keep them here at the house because when the kids are bored and they can't find anything to read, they can read that. They gave them away for free, but I don't know where to get more.
Mm.
Well, I'll tell you what, I'll make sure that a box of pocket constitutions are dropped off at the senior center.
Cool.
Be able to get them
Perfect.
there, okay?
We'll arrange it.
That would be great. I got mine at a 4th of July thing at Perrysburg.
Yeah.
Oh, wow.
Well, I think that
See, you can't.
I think it's important for us to have those. You know what? No matter what you are on the political spectrum, you believe in the Constitution, so that's important. Yes.
And I have access to the Federalist papers because my son read those cover to cover.
Yeah, get your hand
And so I've got them here at the house.
up. Janice has her hand up.
I see a hand up. Go ahead.
Yeah. This kind of ties in what I've been doing yesterday and today. I'm doing some research on who to vote for judges. I live in Lucas County. And one of the things I'm looking at is kind of tied in. And I'm just mulling in my brain what influences judicial review and how that is tied in with how you interpret the Constitution. You know, there's a textual strict way, and then there's a spirit of the law. So yeah, so I don't know, it was just more of a comment than anything else. And it's kind of challenging because, you know, and I understand why, when you look up judges, they can't say what their stand is on things. So you gotta, yeah. And this, you know, I've spent about 3 hours on 9 judges so far. So you can't say I'm not doing my duty, but it's been what I'm doing it for me and my husband, because he thinks I take good notes.
Well,
But it's an interesting process and I'm just learning a lot through that. So it's just kind of a comment, but thanks for letting me comment.
no, I think that's great. And I would encourage you, every one of those candidates, I think, has, the thing I would tell you, have you gone to Judicial Votes Count?
I haven't, but I will. Thank you.
Yeah, that is a through Akron University, but you can access it through the Ohio Supreme Court site.
Okay.
The candidates.
Okay. Thank you so much.
What I would encourage you to do is contact the candidates. If you
Yeah.
apply for them, they've got emails and they'll answer the questions.
Okay. Thank you.
We're just about, well, we're over time, but was there anything else?
How close are you to that train?
Real close.
For you. Well, I cannot thank you enough, Judge Reger. We really appreciate this time you're giving us, especially on your day off. So thank you all for tuning in, and we'll see you next week.
Thank you so much.
Thank you very much.
Bye, everybody.
Bye. Bye.